Turn around for me.
Why?
Because you're under arrest.
For what?
For the incident we talked about earlier today.
What am I under arrest for?
For reckless endangerment.
And how was I recklessly endangering my child?
We're not talking about it.
So we're going to call Mommy and tell them they're taking you to jail because you decided to walk down the street.
Let go of your hands.
That's not his fault.
Yeah, call Mommy.
You're the mother. That's your responsibility.
Yeah,
to keep
I
up
need
with your
you
child.
to not talk to me, please.
Okay. That's
Okay,
true.
Soren, give her a call. Last time I checked, it wasn't illegal for a kid to walk to the store. So.
It is when they're 10 years old.
It is?
Yes.
Okay, I'd like to see that on the books.
Okay, well, you'll see it on your warrant.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, investigations, etc. And so here we have I think we have a very interesting video. This is on the arrest of Brittany Patterson. And let me just start off. I love videos like this. The reason why I like videos like this is because really, I like videos where we can take something that's controversial and regardless of your opinions on it, right? Whether you're for Brittany, you're against Brittany, it's irrelevant to the adjudication process. It really is, because in this case, as we're going to kind of dive into it, whether you're for her or against her, there is court case precedence that's going to, as we go through this, is going to completely pave the way for what can be done and what can't be done, right? What adheres to standards and what doesn't. And so you could be super for Brittany, but you're going to have to, if you care about Brittany's case, we got to look at the case law and come up with an affirmative defense for her. If you're against Brittany, you have to make sure that whatever crime you want to side her with, again, falls into the standard. So our opinions are really irrelevant, right? We're just going to simply, you can call it a cop-out, but we're going to simply walk through the case law precedents, and then ultimately you guys are going to make your own decision. And what's great and passionate about this stuff is it's the reality. So if you don't like the reality of where we currently fall here in the United States or in a certain jurisdiction, man, it's up to you to change it, right? And so that's what's really great about videos like this, right? We don't have to, in my opinion, we really don't have to think very hard. We just have to go straight to the case law precedents and leave it at that. So I enjoy videos like that. So let's get started. Let's talk about what Brittany was arrested for. So there's a Georgia state law, section 16, tac 5, tac 60, reckless conduct causing harm to or endangering the bodily safety of another. And then there's a subsection, conduct by HIV-infected persons. So as you can already tell, this is very interesting why a deputy thought this was a good idea, right? But hey, let's get into it, right? So subsection B is what she was ultimately charged with and arrested for. Subsection B states, a person who causes bodily harm to or endangers the bodily safety of another person by consciously disregarding a substantial and unjustifiable risk that his or her act or omission will cause harm or endanger the safety of another person, and that disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise in a situation, is guilty of a misdemeanor. So basically the big takeaways are that she endangered her child, her 10-year-old son, by with bodily safety, disregarding a substantial risk and unjustifiable risk of allowing her 10-year-old son to go to Dollar General and walk there, pick something up, come home. So that is what she was ultimately charged with. And so when we look at this, I'm going to kind of jump ahead just from a nexus standpoint. It's very clear that this law is vague. It's a vague law. And that's not me saying this, right? We're going to talk about what the Georgia Supreme Court says, but this is a vague law. It's extremely vague, and it's really hard to nail down what the key elements here are that are really enforceable. And so, again, that's not my words. So these aren't my words. That's what's so great about this video. I'm not giving you my words. I'm giving you the words of somebody else who actually has jurisdiction in this venue. Okay? So now that we got that, so let's look at the common sense standpoint, because I think the common sense standpoint is important to what we're talking about, and ultimately it's going to be something that is going to that's going to come up again. So as we're looking at this, we're going to notice very quickly the interesting aspect of this is the fact, as you can see here on the screen, this Georgia mom, again, Brittany Patterson, was arrested by deputies on October 30th. And again, according to what was said, after a witness reported a juvenile in the roadway who had gone and left a nearby Dollar General store, according to Fannin County Sheriff's Office report. So as you can see, this female deputy on the right thought she had probable cause and thought it was a good idea, or at least a lawful idea, to arrest Brittany Patterson here for, again, that reckless endangerment statute that we just talked about. Now, from a common sense standpoint, what's really interesting is the fact that what happens the very next day, people? Boom, look at this picture right here. Halloween. Look at all these kids, right? These kids look like they're dressed up, having fun, and they're doing what's called trick-or-treating. And for those of you guys that, and I'm not trying to be funny, man. Like we got to logically put this together, right? Like I'm not trying to be funny. I'm trying to logically put this together because you have a law enforcement officer who actually thought this was a good idea, right? So again, we got to flush this out using the facts and the receipts that you guys are seeing. So theoretically speaking, this deputy was like, the fact that this child, 10 years old, by himself, walking to a Dollar General store during the daytime hours, that is such a gross, negligent act by the parents. It deserves justice. It deserves to be adjudicated in court, and the mom deserves to be arrested. And then the very next day, millions upon millions of kids are going to flood the streets all over the country, and hundreds of thousands, if not millions, in the state of Georgia are going to do the same. And if you look at the reports and you look at everything, not one Georgia police officer, from my understanding, from what I've seen, arrested a parent for allowing their children to go trick-or-treating that day. So the very next day, Georgia streets, this county, streets are flooded with kids trick-or-treating without parental supervision. No arrests were made. It's a wild concept. And it's even more wild because when we look at, again, let's look at the popularity of this, right? Because this is, if you look at the statute again, right? A gross deviation, right? A gross deviation from the standard of care, from what is considered standard practice, right? As you can see here in 2022, 76 million children participated in Halloween trick-or-treating. Not Halloween, trick-or-treating. 76 million. 72% of households handed out candy in 2022. Wow. And so if you look at it in 2021, only 64%. So as we can see, it's going up. More and more people are doing this. So the idea that this is not, that this is somehow a child walking on their own without parental supervision is a deviation from standard care. I don't see how that's flushed out. I don't see where the articulation of that's going to be when, again, the very next day you have Halloween. We know that Halloween is a multi-billion dollar industry, 10.6 billion approximately in 2022. So again, this is not only a real reality, as you can see here, subsection 3, it is growing. In this decade alone, 25% increase. So this is a growing market. This is a growing cultural phenomenon, if you want to call it that. And so it's just kind of wild that to think that a deputy is somehow going to attempt to articulate the elements of a crime here. Again, it's not my words. It's not my words at all. So let's talk about, what the courts actually said, because what the courts actually say matters. So here we go. Georgia Code 16, TAC 5, TAC 60, 2024. Now, we have to look at Georgia Supreme Court case of Hall versus State of Georgia, 1997. And here, this Georgia code was seen as constitutionally vague. Okay, so here the state's argument, when we're talking about in the Hall versus State, that the required notice of prohibition against certain conduct is satisfied by the mens rea element of conscious disregard, as set forth in the statute, is entirely unpersuasive. Under the precedent discussed above, the state of Georgia's argument could only make sense if the statute was purported to prohibit a mental state of conscious disregard, which of course it does not. As it is, the Georgia statute failed to provide Hall with fair notice that she could be held criminally responsible for leaving the children in the care of her oldest son, who I think was 12 or 13 at the time. And therefore, it failed to clearly define its prohibitions, rendering this Georgia Code, 16 Tech 5 Tech 60, unconstitutionally vague. This statute has already been played out in court and deemed unconstitutional, right? It's unconstitutionally vague. Again, these are not my words. I didn't come up with this. I'm not on this Georgia Supreme Court. This is 1997, people. 1997. This is years. This is years before this incident even occurred. And so, again, the idea that you have a law enforcement officer that's like, oh, that's a great idea. Let me go ahead and arrest this person. Furthermore, all the charges against Brittany Patterson have been dropped. And then this bill, HB 552, is called the Brittany Peterson Act. And it's something that is going through the legislation. A bill is to be entitled the Act to amend Section 15 Tac 11 Tac 2 of the Official Code of Georgia, annotated relating to the definitions relative to juvenile code, so as to revise the definition of neglect to amend Chapter 5 of Title 16. And so essentially what it's going to do is it's going to allow certain exceptions for certain offenses of reckless conduct and child cruelty for parents and legal custodians permitting children to participate in independent activities under certain conditions, to provide for a short title, to provide legislative findings and intent, to provide or relate matters, to provide an effective date and applicability, to repeal conflicting laws for other purposes, etc. So finally, right, we're seeing that a bill is being enacted to, again, do what it says it's going to do, which is going to allow children to participate in independent activities. And here's the kicker, guys. Here's the kicker. We know that children are already participating in these individual activities, right? Trick or treat. We just gave you a great one. Walking to school, walking home from school, walking to different activities, parks. Children are already doing this, and they have been doing this since the dawn of time. So again, this just goes down to what we've talked about previous on this channel. It's a leadership issue. You know, you don't know what you don't know. And so the scary, right? So this is the scary facts of this, is that, you know, it took me zero research, not very long. It took me a matter of minutes to put this video together, which should shock you, right? Like literally I was able to use my common sense and articulate, okay, this is vague. Where else does it say this is vague? I can't be the only one. And I quickly found this. I mean, it took minutes of research to put this together. This is not something that took me a long time. I don't want you to think it did. The common sense standpoint of this should bring any law enforcement officer to pause. But again, you don't know what you don't know. You know, I want to reaffirm that constitutional law and case law is not something that officers are taught in. They're not taught in problem solving when it comes to case law, when it comes to constitutional law, when it comes to academic prowess. Police officers are not taught it. They're not taught these deconfliction and risk mitigation tools. They don't have these tools in their tool belt that are taught on any statewide level, right? The academies don't teach this. Individual FTOs don't teach this. You have supervisors that have been supervisors. They've been sergeants after 2 or 3 years of being on the road. So again, you can blame whoever you want, but the truth of the matter is, it's not really, doesn't really matter, because these officers don't know what they don't know. You know, you can blame the partner, like, why'd you think that was a good idea? Well, the sergeant, the supervisor, why'd you think that was a good idea? Well, the truth of the matter is, they have no idea about Hall versus state of Georgia. They don't know what they don't know. And apparently, we can't allow common sense to try to dictate, you know, a standard reason of approach here. And so it's truly scary. And this is truly one of these videos that, you know, it's very concerning. And I see why it's very concerning for people. You know, it's, you know, again, you can call it whatever you want, but the Georgia Supreme Court stated, you know, 25 plus years before this incident occurred, hey, this law is unconstitutionally vague. I just want to throw it out there, you know. So why the legislators decided to keep it, I don't know. But this is true in all cases. And every state, I'm sure, has laws. I know there are states, for example, there are statutes, the state of Oklahoma, for example, that there is these laws that just by face value are not constitutionally permissible, but they're still codified in state law. And so again, that's another issue in and of itself. But again, we want to think that common sense is common. It's not. We want to think that officers are going to stand up and do the right thing. They should, but they don't know what they don't know. And if they don't understand and they don't have the jurisprudence acumen to actually be aware and comprehend what's going on around them, I mean, what do you expect? Again, I'm not trying to be mean. I'm just pointing out realities here. So there you have it. What do you guys think? The most important thing, the one thing I care about the most is, what do you guys think about this? Should common sense have told any reasonable person that, pause, let's look at this? Do you think the deputy was right? Do you think this is just a bad Georgia Supreme Court case precedence? Do you think that she was totally in the right for making the arrest? Do you think the mom was totally in the right? I want to hear what you have to say in the comment section below. Please tell me your thoughts and opinions. I hope this video was helpful for you guys. If you like this content, guys, please like, share, subscribe. And as always, guys, long live the Republic.